Welcome. This is a guide to getting a divorce or legal separation with children in the state of Colorado. First, you'll need to decide how you're going to file. If you're going to file on your own, then you'll need to complete the case information sheet, the petition, and the summons. Make sure you draft, sign, and execute and notarize all forms. These forms will then need to be served on opposing party. Once the opposing party is served with the forms, you may file in the district court. Service may be easier to do first. This way, if you don't serve upon opposing party, you won't be wasting filing fees in the district court. If you're jointly filing the documents, you'll only need a case information sheet and a petition. Summons is not necessary for parties that are filing jointly. The parties will need to execute the same documentation and file directly with the district court. No process of service is necessary. In order to have jurisdiction in the state of Colorado, either party must reside in Colorado for at least 91 days prior to filing the documentation. File the documents in the county where you or your spouse reside. This is the appropriate county to file in. Once the court receives the documents, they will set an initial status conference. Make sure to mark this and do not miss this date on your calendar. The initial status conference typically takes place on around 42 days after filing the initial documentation. For service issues, if you're filing on your own, you'll need to find a non-affiliated person who is at least 18 years of age or older that files all documents on the opposing party. This person will then need to notarize what is called a return of service. This, in turn, will be filed with the court. Once that has been filed, the court will see jurisdiction, and they will issue what is called a case management order, or a CMO. The CMO details the procedures that will take place for the rest of the case. The sworn financial statement is a document that is required by the district court. This document must be completed by both parties. This document dedicates incomes, assets, debts, and liabilities. Make sure to fill this out in full and give full disclosure. The certificate of compliance, this shows that you have found and sent supporting documentation to support the sworn financial statement to the opposing party. The separation agreement, parenting plan, decree, and support order are typically filed if all issues can be resolved by the parties. The pretrial statement, this will be filed by both parties, but typically only if you're headed for trial and the issues cannot be resolved. Finally, the status conference will take place, like I said, 42 days after you have filed the documentation. Prior to this conference, you'll want to have completed the parenting class, which is mandatory in the district court. If you and the other party agree on all issues, you will then schedule a final hearing where you'll attend, and the court will issue the decree and support order on or after the 92nd day. If, however, you and the other party do not agree on all issues, then you may be required to attend mediation, or a contested hearing may be set. The decree and support order may be entered at the conclusion of your final hearing after that takes place. If you have any questions with regards to the process, please feel free to contact an attorney at Mantia Family Law.